Tēnā koutou. A warm welcome again to our final session of this workshop, our final panel session on the rule of law at sea. So for those of you who are now joining us for the first time, just again the rules of how we run those panels. If you are online, you should please use the Q&A session to ask questions. The raise hand function is not working properly. We also have, as per usual with the previous sessions, 15 minutes for the panelists. We have 4 panelists in this session, so we have extended the time for this panel to allow for the same amount of discussion. For the people that are in the room, again, if you could please raise your hand, and once you have the go-ahead from me, introduce yourself and ask a brief question to the panelist. The discussions follow the Chatham House rules. We do record the presentations. We do not put the discussion online to create an environment of trust amongst the participants and the panelists. It's my pleasure to be welcoming a very esteemed list of panelists on this last final panel on the rule of law at sea. Our first panelist, she just made it on time, she had back-to-back meetings, is Professor Natalie Klein from the University of New South Wales in Sydney, and she's also the Australian Research Council Future Fellow. And today, Natalie will talk about informal agreements and UNCLOS as a living treaty, which links us to some of the issues we've just discussed before, and will give us an example from responses to navigational threats. So please welcome Natalie to the virtual floor. Thank you.
Great. Thanks very much, Bjorn. I'm just looking to share my screen, which looks like it is happening. No. Slideshow from beginning. All right. First of all, I'd like to thank very much the organisers of this workshop to have the opportunity to have attended all of the panels so far. The discussion has been really fascinating, and I feel like the bar has been set high for my own intervention today. And in doing so, I'm drawing on some ongoing work that I'm doing that is looking at informal agreements generally in the law of the sea. And I wanted to tie it into our theme in considering UNCLOS as a living treaty. To what extent can we see how this treaty can change over time? And I wanted to use the example of some different instruments that are dealing with navigational
Natalie,
safety.
to interrupt you already.
Sorry.
Could you please change your display settings to mirroring the presentation, because we can see your next slide as well. If you go to the top, the middle of your top, display settings, between show, taskbar, and slideshow.
On the PowerPoint?
Yeah, in your PowerPoint on your screen.
Display settings.
If you go from beginning again.
It just automatically brings up the display.
Can you see the display settings on the top of your screen?
No, not anymore. Can I just run with the one that I've got?
Sure.
Oh, I'm just checking because the settings are otherwise only showing me.
It's fine, it's just a little smaller, but please go ahead and apologize.
All right, I'm sorry. Yeah, sorry, I was checking some other settings. Let me move on to my next slide. In any event, I guess there'll be no surprises about what's coming next. All right, what I wanted to start off with is the outline in terms of what I wanted to address was to give you a brief introduction around the use of informal agreements in dealing with certain maritime issues. and go through 3 examples in relation to navigational safety. As I mentioned, the Code for Unplanned Encounters at Sea, to look at 2 memorandum of understanding that have been entered into between US and China, and also, of course, the well-known Declaration of Conduct that's in place between ASEAN and China. And of course, there are discussions now about a potential code of conduct, and also consider the significance of those agreements, particularly as set against UNCLOS and how we understand the rules set out in that treaty. So just so you know what I'm talking about in terms of informal agreements, we talk about soft law a lot within international law. So the idea that we have agreements that are not formally legally binding. They're not a formal source of law in as much that they're not treaties, they're not customary international law. But when we look around, we see that there are many different agreements that have been put in place. And those agreements come about through a process of informal lawmaking. And so this has been described differently by various commentators, and it generally involves a process of international cooperation to reach these agreements. It's usually between public authorities and may or may not involve participation of private actors or international organizations in varied institutions and networks. And in that regard, probably it's also worth observing in the law of the sea context that we also have examples of instruments which are developed by private actors, but then are also endorsed by public authorities. And one example we could point to in that regard is the San Remo Manual, which deals with the laws of naval warfare. But everyone would be familiar with examples of informal agreements in the law of the sea, and indeed they were being referenced in each of the presentations that we heard this morning on climate change. And I could add to those examples from also the fisheries example, where we have the FAO's International Plans of Action. We also have examples where the Djibouti Code of Conduct dealing with piracy. And of course, the IMO develops various guidelines, recommendations, also interpretive understandings. And all of these are different forms of informal agreement. But the questions that we then have to ask is, well, what do all of these mean for us as international lawyers? And in looking at the examples from the safety of navigation, I think there's actually some questions we have to ask about whether we should be embracing these sorts of agreements in all circumstances. The incentives for using informal agreements are fairly clear, and this list comes from some writing by Schaffer and Pollack, who have gone through and looked at this phenomenon in international law more generally, and I think applies in the context of the law of the sea. Obviously, when agreements are not formally legally binding, you're going to find that it's easier to negotiate and less costly because of the people that you have to have involved. And tied into that is this idea that there are lower sovereignty costs because the stakes are perhaps lower when you're not concluding a treaty to which a state would be formally bound, and you don't have to go through a whole process of then implementing that treaty into domestic law. When it's an informal agreement, it may not be implemented in the same way. It might find its way into policy statements perhaps, or just in terms of actions, but doesn't involve the same cost and effort that would be involved with a formal treaty. So precisely because of those characteristics, we'll see that there's a lot of flexibility that's built in, and that helps for states to cope with uncertainty. And also, once you have an informal agreement that comes without some of the baggage of legal responsibilities from treaties, it gives states and other actors a chance to sort of road test particular agreements and potentially learn from them and adapt them and change over time. So it provides this mechanism for states to perhaps be ambitious in some circumstances and go a bit further than they might be willing to go in a particular treaty. And also the engagement of non-state actors is another reason that states move towards, or other public actors move towards, informal agreements, non-state actors that can't necessarily adopt treaties in their own right, but other actors who have an interest in trying to reach agreement on particular international issues, can see the informal agreement as a way of sort of bedding down shared expectations about how a particular issue is going to be addressed. So in relation to the three particular examples that I wanted to point to in the realm of navigational safety, I think it's fair to say that with each of these examples, they have been a product of particular tensions that were existing between the actors concerned. And these informal agreements were partly seen as a way of responding to that tension and trying to come up with a mechanism that would allow them to say, well, this is the conduct that we expect that should be in place when we're trying to resolve these particular issues. So then the question to ask is, well, what has been in these agreements and what significance does that have for UNCLOS or other existing rules of international law? So to turn first of all to the Code for Unplanned Encounters at Sea, that particular instrument is described as offering a means by which navies may develop mutually rewarding international cooperation and transparency and provide leadership and broad-based involvement in establishing international standards in relation to the use of the sea. So the cues were initially adopted by the Western Pacific Naval Symposium. Since that time, it has also been endorsed between ASEAN and China. And also the Indian Ocean Naval Symposium has considered also whether it should adopt something similar to the cues. I don't think it has formally adopted it yet, but I know it has been under discussions. Now, the cues essentially have two main aspects to them. First of all, in relation to dealing with navigational safety, as I mentioned, but also to try and provide for certain communication procedures as well. What's interesting when you start looking at the different rules within the cues is the extent that they reiterate requirements within the coal regs. And one of the things that I thought was interesting in thinking about it in relation to rules under UNCLOS is that it includes a list of measures that the prudent commander might generally avoid, which includes simulating attacks or discharging weapons or other objects or using lasers in a harmful manner or in the direction or vicinity of the vessels or aircrafts encountered. So given that they set out this particular list of measures that should be avoided, can we then say that when we're trying to interpret our obligations of due regard, either in the exclusive economic zone or on the high seas, could we look to this list of measures and say, well, that provides us with the particular guidance that we need? The extent that we can rely on this instrument, though, I think is undermined by the fact that it's very explicitly stated that the cues is not legally binding under international law. So in this regard, it's quite clear that cues status under international law is not one that kind of creates responsibilities as such. So then the question is, well, can it be used in other ways? Can we use it to try and interpret obligations under UNCLOS? And there we need to turn to our rules of treaty interpretation and whether this would count as a subsequent agreement. And probably if we look at the requirements to meet that standard within the Vienna Convention on the Law of Treaties as discussed by the International Law Commission, we'd probably have to say, no, it doesn't really count in that regard. And certainly in terms of the status of the cues, it's quite discretionary as to whether navies will sign on and adopt them or not. And in terms of questions of state responsibility, it's explicitly provided that the cues does not constitute an international agreement or treaty, and as such is not legally binding under international law. So we'll come back to some of the significance of that agreement, but I find it's kind of an interesting dichotomy on the one hand in terms of coming up with international standards as it says that it's purporting to do, but on the other hand being so firmly disavowing the relevance or application as international law. In a similar vein, we can turn to the two different China-US memoranda of understanding. Now, these sit within a legal framework which was established by a 1998 bilateral treaty entitled the Agreement on Establishing a Consultation Mechanism to Strengthen Military Maritime Safety. Now, the notification MOU, I'll just mention first of all, because it creates a frame for exchange of information and use of observers, and it's explicitly entitled as a confidence building measure. And perhaps at the end of the day, this informal agreement, it only is a confidence building measure, and we can't read anything more into it. I find the behaviour MOU a bit more interesting to look at because it describes itself as an effort to strengthen adherence to existing international law and norms. But the legal status of the behaviour MOU is set out very clearly in section 5, which provides that the memorandum is not intended to be binding under international law. The memorandum is not intended to affect the rights or obligations of either side under relevant international agreements or customary international law, and that the memorandum is made without prejudice to either side's policy perspective on military activities in the EEZ. So we have all these very explicit statements about how the behaviour MOU is not to be binding under international law. Yet once you start going through it, its prescriptive content is quite striking, to the point that what is set out within the behaviour MOU is described as a series of rules. And what it also does in its various annexes is essentially use legal definitions and particular provisions that we find in the Qs, that we find in the coal regs, that we find in UNCLOS, also the International Code of Signals. So it goes through and it draws rules from both formal sources of international law and informal sources of law and brings them all together as a way of guiding the behaviour of these two countries when they encounter each other in certain circumstances at sea. And similarly to the Qs, it also has a list of measures that a prudent commander or master generally should avoid. So once again, we've kind of got this interesting mix within a particular agreement that has what might be seen as normative effect, but clearly no normative intent. So the third example I wanted to look at, and noting that my time is starting to run short as well, is the Declaration of Conduct. And unlike the other two instruments I mentioned, it's extremely threadbare, I think, when it comes to international law. And all we really see is that the parties reaffirm their respect for and commitment to the freedom of navigation as provided for by universally recognised principles of international law. There's no elaboration on that. There's passing references to navigational safety as well. So what we can see with this is that the Declaration of Conduct is very much probably falling in that category of being a confidence building measure, because all it's really doing is reaffirming existing rules of international law. What it does do is create mechanisms for implementation, which does allow for practical consequences, and that can be a benefit of informal agreements. But certainly in the context of the Declaration of Conduct, it does seem that perhaps when actions are contrary to that, it would undermine its normative effect in different ways. So it does raise this question about why informal agreements are being used to respond to navigational threats. And it does seem that one advantage of going through this process of creating informal agreements, that the very process of creating the agreements provides opportunities to discuss what expectations are and what the standards should be around behaviour. And I think there's some very practical consequences that come up in the operational day-to-day decision-making for commanders of vessels who are confronted with situations that they need to address, and what particular rules of the road they need to follow, as they'd be familiar with from the coal regs. Now, I think there is potential for informal agreements to have normative effect in international law, as I mentioned, through treaty interpretation and other reasons as well. But what I wanted to highlight was that there are absolute risks here, and I have some hesitancy in suggesting that there is a good reason to pursue informal agreements where you are going to be replicating existing rules of international law. They serve perhaps a diplomatic purpose or perhaps a political reason for doing so, in terms of reaffirming adherence to international law, but it's not necessarily providing any clarification or not necessarily promoting transparency or not necessarily providing mechanisms to see how a living treaty could evolve to respond to modern day circumstances. And certainly some commentators have been concerned about following this process, and Krasker, in commenting on the China-US memorandum, has rightly noted that, are you in some way degrading existing international law principles when you enclose them within an informal agreement that you say is not to be considered binding as a matter of international law? Should we just be sticking to the formal agreements? So I think it's very important to consider that any informal agreement is not going to be antagonistic to existing international law. So just to conclude, what informal agreements may do is elaborate on the details of broad international law principles, and there is possibility for them to have normative effect and to affirm the rules-based order of the oceans. But I also think we need to be very alert to the possibility of an informal agreement moving away from or being antagonistic to existing legal rules. And so the full implication of their use really must be appreciated, and especially when we're dealing with issues as important as navigation and the ongoing status and relevance of UNCLOS. So thank you for your time, and apologies for the slideshow issues.
Thank you, Natalie, and apologies from my side for barging in right at the beginning of your presentation. And thanks for making it in time to kickstart this panel discussion. So our next speaker is Professor Stuart Kaye, and he is the Director and Distinguished Professor of Law within ANCHORS, the Australian National Centre for Ocean Resources and Security. And today, Stuart will talk about the freedom of navigation and grey zone tactics in the South China Sea, so linked to our public event today, this evening. So, Stuart, the floor is all yours.
Thank you very much for that, and I'm delighted to join in this workshop. I think it's a wonderful event, and all those concerned with it are deserving of praise. Now I'll do the same and endeavour to share my screen, and hopefully now you have the presentation. What I'm going to be talking about, as you've heard, relates to issues in and around China's grey zone tactics. Now, to provide a bit of background, I'm going to talk about the grey zone activities in the South China Sea particularly, and also a little about issues of state responsibility with respect to those activities, and then draw some conclusions out of recent events, particularly the ongoing incidents at Whitsun Reef in the South China Sea. Now, for those who aren't aware, China maintains a reserve militia force that operates at sea. This is usually referred to in English as the Maritime Militia. Exactly how big it is uncertain. Reports from China in 1979 expressed that it had 750,000 members. And in the 2010 China Defence White Paper, this had grown to 8 million members, which in terms of just numbers of people is truly staggering. And the number of vessels that it maintains, these are largely fishing vessels, and some on the screen there now would be examples of typical maritime militia vessels. And there are about 140,000 of these. So it's quite a sizable outfit, albeit not heavily armed. In terms of grey zone activities, these are efforts where typically maritime militia vessels will turn up in places and harass or attempt to prevent other uses of the ocean by other states. So famously, the USNS Impeccable in 2009 in the East China Sea was harassed for 3 days by 14 Chinese fishing vessels that attempted to prevent it from making way. There have been harassment of Vietnamese survey vessels, the prevention of the Philippines from resupplying individuals who were on Scarborough Shoal, efforts to try to prevent fishing activities, and swarming activity, as it's been described, preventing resupply of the Philippines garrison at Thitu Island. And the most recent activity that could fall into this category is at Whitsun Reef earlier this year. Now, Whitsun Reef, if you've not heard about it before, is on the screen. It's a not an occupied feature, probably because it's not an enclosed atoll. And you can see there are lots of little white spots appearing inside the cleft of the atoll there. And in these circumstances, they are all Chinese fishing vessels which are appearing at anchor. At a closer level, we can see them here from the air and from the sea, and they're basically large numbers of vessels that have all been lashed together and are just parked in the lee of the reef itself. Now, China has been asked what these vessels are doing, and they're saying, oh, look, they're just taking a bit of a break, having a bit of a breather from fishing activities, seeking a bit of relief from some storm activity. But they seem to have been there for some months. So they either need rather a long time to recharge the batteries or their presence there is simply to be present. And this has irritated the government of the Philippines particularly very, very much. Now, in terms of the status of the feature, Whitsun Reef itself is a low tide elevation. Parts of it do come out of the water at low tide, but otherwise it's completely submerged at high tide. So it doesn't generate a territorial sea of its own force. It's also not within 12 nautical miles of anything that is clearly identifiable as land, by which it could generate a territorial sea were it to be so. The nearest features that are recognised as land are Namyet Island and Sin Kaye Island, both of which are occupied by Vietnam. There's also a feature quite close to Whitsun Reef called Grierson Reef, which Vietnam has also occupied. Now, there's Whitsun Reef that you can see on this satellite photograph, and Grierson Reef, if you're curious, is marked there with the red circle, and it's only 6.2 nautical miles away from Whitsun Reef. So if it's land, Whitsun Reef itself would be within a territorial sea, and that would raise different issues with respect to long-term anchoring in the lee of the reef. As to what Grierson Reef looks like, this little animation shows you. Some of my colleagues here at UNCLOS have come to refer to this as Apostrophe Island because of its rather distinctive shape. But it is an artificial feature. It's been built on the reef. You can see on this diagram where limestone has been carved out of the coral to help build it up. And apart from the distinctive tail, you can see the feature has an extraordinarily regular shape. So I'm assured that it was below water before this construction took place some years ago. The tail does vary from time to time, so it doesn't always look like an apostrophe. So if that feature is not a land for the purposes of the Law of the Sea Convention, then Whitsun Reef is more than 12 nautical miles from the nearest land, and so therefore the waters within it are outside the territorial sea and would therefore be part of an exclusive economic zone. And based on the decision in the South China Sea arbitration, that exclusive economic zone belongs to the Philippines because Whitsun Reef itself is about 190 nautical miles from Palawan Island, which is the nearest land otherwise there. So the legality of the Chinese anchoring in these waters becomes a question, first of all, of state responsibility. And we have two elements, obviously, from the articles on responsibility of states for internationally wrongful acts drafted by the International Law Commission. First of all, we have to have attribution to the state, and the second, we have to have a breach of an international law obligation. So turning to attributability, which in theory should be our difficult one, we've got this being done by a whole lot of fishing vessels. Now, if they've been directed by China to be there, then that is attributable to China, but China isn't saying that. It's saying the vessels are simply at anchor. So then we've got, well, are they directed or controlled by the state? Well, if they're there under maritime militia orders, then clearly this would also be attributable to China. But China isn't prone to identifying vessels as maritime militia, nor do they tend to tell us what orders they've given the maritime militia, which is not surprising. You wouldn't expect that to take place. So although we might suspect that they're being directly controlled by the state, in these circumstances, we can't be certain. The next step would be that the conduct is acknowledged and ultimately adopted by a state as its own, where the conduct might not be initially attributable, but the state's behaviour is such that it acknowledges and adopts the conduct in question. And a good example of this came from the Tehran hostages case after the occupation of the US Embassy and consulate in Shiraz as well. Now, in these circumstances, a case can be made that China is ultimately accepting what is taking place here. Certainly, this has been the view of the Philippines with respect to swarming behaviour in the past. When Thitu Island was swarmed in 2019 and its resupply was effectively prevented by large numbers of these vessels, the Philippine government issued the statement that's on the screen, and I'm highlighting the portion that says such actions, when not repudiated by the Chinese government, are deemed to be adopted by it. And so the Philippines, one imagines, would take the view that if the government of China isn't doing anything to get these vessels to move along, that it's effectively adopting their behaviour and therefore it should be attributable to them. Which then leads us to the second half of the equation, and that is there has to be a breach of international law. And for this, we need to remember that the vessels are at anchor in the exclusive economic zone. And the relevant provision here is Article 58, which notes that you have certain freedoms that are available on the high seas in the exclusive economic zone. These include navigation and overflight, although there needs to be due regard to the rights and duties of a coastal state. So the question is freedom navigation going to be also including the right to anchor? And there's very little international discussion of this issue, but there is an article that one can access on the US military's web pages that can be accessed from the internet. And this discusses at great length the prospect of long-term anchoring as a high seas freedom. It was written by a US naval officer during their postgraduate training at the Naval Postgraduate School in Monterey, and the individual concerned is still within the employ of the US government. Now, whether this represents the US position or not, you could argue, but certainly it's not inconsistent with the positions that the Americans have done. The idea is that since you have freedom of navigation, that doesn't mean you need to be underway, and therefore being at anchor in the exclusive economic zone of another state doesn't impact upon your rights. So you have a freedom of navigation, and this could include stopping and anchoring. You can't do it in such a way as to detrimentally impact upon the rights of coastal states, however. So to do so to block would be potentially problematic. Now, does this amount to claiming an area of the high seas? Because this also falls within the remit of Article 58. And no state can purport to claim an area of high seas. So you can't sort of set up with your vessel in long-term anchoring and seek to remain forever. Now, in this instance, the South China Sea Arbitration, the arbitral tribunal here, formed the view that nothing that China had done with respect to its 9-dash line, which they found to be unlawful, amounted to potentially claiming as areas under sovereignty the South China Sea. They noted that the Chinese side had issued statements that it respected freedom of navigation and overflight in the South China Sea. The tribunal also went on to say that that commitment meant that the areas couldn't, within the 9-dash line, couldn't amount to territorial sea or internal waters. And therefore, this didn't amount to a physical claim. Now, there's nothing in any of the statements by China either suggesting that the long-term anchoring in the lee of Whitsun Reef amounts to any sort of claim in that regard that would be different in nature to what China has asserted before and was dealt with by the court at great length. So what can we draw from all of this? Well, to be honest, earlier grey zone activities by China, the swarming, the preventing of resupply and the like, are obligations that I think could be attributed to China and ultimately would be in breach of the due regard obligation in Article 58. Preventing vessels being able to navigate freely and to go about their business is clearly going to be a breach of international law. But it's arguable that simply anchoring at Whitsun Reef doesn't necessarily amount to a breach of Article 58. And this could be a sign of a new phase in grey zone activities. I would argue that it might suggest a more sophisticated analysis coming from China underpinning their activities in the South China Sea. Previously, China had simply asserted the 9-dash line, ultimately extending the dashes to a 10th, and saying everybody keep out, that foreign vessels passing through should go away. If they were military vessels exercising purported freedom of navigation. And this was all very blunt and rather crude. This suggests that things are sharpening up a bit, that China has taken a look at the Law of the Sea Convention and has done something which is deeply annoying to the government of the Philippines without necessarily breaching international law at the same time. And that suggests a greater level of sophistication. One might argue that engagement with ASEAN through the COC negotiations also suggests a stronger engagement by China with trying to comply with the Law of the Sea Convention while still trying to assert rights in the South China Sea. And also the Chinese Foreign Ministry openly floating the prospect of a continental state archipelago being valid under customary international law, maybe the next step for what they seek to apply in the South China Sea. So if China is going to be engaging at a more sophisticated level, then certainly for other littoral states, it will be a more complicated environment and one which they'll need to carefully assess what the Chinese are doing in order to frame responses which will remain within the fabric of international law. Thank you all very much.
Thanks a lot, Stuart. Our next speaker is Professor Kentaro Furuya. He's adjunct professor at the National Graduate Institute for Policy Studies and also professor at Japan Coast Guard Academy, so a real expert on maritime security issues. Captain Furuya will present on the rule of law and maritime law enforcement. Welcome to the panel.
Thank you very much for your kind introduction, Kia ora, and then good afternoon from Tokyo. Let me express my sincere appreciation to the organizer, Victoria University of Wellington and the Embassy of Japan in New Zealand for having me to this important workshop. I am excited to be a part of these distinguished members of this panel. Today, I'd like to talk about rule of law and maritime law. And first, I will brief the law enforcement activities at sea, their uniqueness, and the different roles of international and national law in law enforcement operations. And I will also briefly touch upon the rule of law at sea, focusing on the three principles articulated at the Shangri-La Dialogue in 2014. Lastly, I will argue the emerging threat against the rule of law by the maritime law enforcement activities, focusing on the recent enactment of the Chinese Coast Guard law. Law enforcement activities are exercise state power to give effect domestic laws and regulations over incident or event under its jurisdiction through police officials. So what law enforcement officers enforce is not international law, but national law. international law need to be incorporated or legislated in the domestic legal system to exercise enforcement jurisdiction and for a court to the state to hear the case. At sea, law enforcement activities are more complicated than at land. At the land territory, police officers exercise their police power over any incident or event whenever they recognize as a violation of laws and regulations. Regardless of nationality or the suspect, the police officers have the power to arrest the suspect and seize property as evidence. The land territory is under full sovereignty of that state. However, when it comes to the sea, police officers, in many cases, Coast Guard officers or naval officers in charge, need to be aware of international law. Since the ocean is a part of global common, maritime law enforcement operations need to be in conformity with international law. For example, the state jurisdiction is allocated through international law, including the UN Convention of Law of the Sea, or UNCLOS. According to the UNCLOS, the sovereignty of coastal state extends to the territorial sea, but subject to the right of innocent passage by foreign ships. Whereas the coastal state has only sovereign rights over natural resources in their exclusive economic zone. That is to say, UNCLOS allocates state jurisdiction based on the different maritime zones. In addition, warships and other government ships operated for non-commercial purposes enjoyed immunity. Even though a warship violates national laws of the coastal state, the warship is free from exercise enforcement jurisdiction, such as coastal boarding and inspections, even investigations by other than the flag state. In this way, international law and national law have both significant but different roles to play in law enforcement activities at sea. International law allocates state jurisdiction in different maritime zones, whereas the national law defines activities which constitute a crime. Moreover, a condition to exercise jurisdiction at sea is an incident, is illegal under national law and within the jurisdiction of the state under international law at the same time. Despite an illegal activity, a state may not exercise jurisdiction if it is committed outside of the jurisdiction of that state. The court of state will not be able to hear the case, which is the purpose of law enforcement activities too. Maritime law enforcement officers need to understand these different roles to exercise police powers at sea and effectively. Next, I'd like to move to what the rule of law at sea is. In answering this question, the Prime Minister Abe advocated 3 principles of the rule of law at sea at the Shangri-La Dialogue in May 2014. These principles are, number 1, the making and clarifying claims based on international law. 2, not using force or coercion in trying to drive their claims. And 3, seeking to settle dispute by peaceful means. From this perspective, the UNCLOS plays an important role again. As a constitution at sea, the UNCLOS provides different rights and obligations to states, which serve a legal basis of the claims by states under international law. In addition, the UNCLOS established an International Tribunal of the Law of the Sea, or ITLOS, for the peaceful settlement of disputes and maintenance and development of international legal order at sea. And the rule of law at sea is often important in law enforcement activities to avoid escalations and maintain legal order at sea. Essentially, its allocation of state jurisdiction is for avoiding possible conflict with other states in exercising state power. The immunity of warship is helpful to promote diplomatic solutions rather than the on-the-spot coercion measures, which often lead to escalation. Therefore, to avoid escalation at sea and international conflict, law enforcement activities at sea need to be in conformity with international law. National law should be enacted, therefore, based on international law, including the UNCLOS, which carefully balance the navigational rights and other rights of the foreign states and the right of coastal state to exercise its police power in different maritime zones. In sum, law enforcement activities at sea are an application of state power at sea, which include coercion measures. Therefore, in particular, what the Professor Stuart says, in the so-called gray zone situation, which is not wartime, but not purely peacetime, and the violation of international law does exist, observing the principle of the rule of law at sea mitigates a possible escalation and conflict at sea by law enforcement activities at sea. So from this perspective, one serious challenge in East Asia is the recent enactment of Chinese Coast Guard law. There are numerous controversial provisions in this law, but here I will highlight a couple of the most serious provisions against the rule of law. The Chinese Coast Guard law took effect on February 1st this year. The Chinese Coast Guard was originally established in 2013 by merging separate law enforcement agencies such as China Maritime Police, the State Oceanic Administration, China Fisheries Law Enforcement, and the General Administration of Customs, and placing them under State Oceanic Administration. In 2018, the Chinese Coast Guard was restructured into an organization officially known as the Chinese People's Armed Police Force, Coast Guard Corps, and placed under the command of People Armed Police Force, which is supervised by the Central Military Commissions. The duties of the Coast Guard were enforce laws at sea and safeguard maritime rights and duties, but at that time, without legislation in place to govern its activities. After being in November 2000, finally, the National People's Congress unveiled the draft of the Chinese Coast Guard law. And after being amended, the law was officially passed by Congress on January 22nd this year and came into effect on February 1st. The Chinese Coast Guard law designates the Chinese Coast Guard as an important maritime armed force that is under the command of Civil Military Commission, the Central Military Commission, as well as enforcing maritime laws and protecting maritime rights and interests. The Chinese Coast Guard has also been assigned to carry out defense operations. The reason why this law is highly controversial is that a Chinese Coast Guard law legitimates some law enforcement activities by the Chinese Coast Guard that are not clearly based on the rights under the international law. In other words, the Chinese government would disrespect the rights and obligations under international law, including the Law of the Sea Convention, but justify their activities by providing domestic law and make it a domestic law enforcement issue rather than the issue of violation of international law. This is clearly contradicting to the first principle of the rule of law at sea, which is making and clarifying claims based on international law. Application and enforcement of such provision would be legal only internally, but illegal internationally. The Vienna Convention on the Law of the Treaties, Article 27 provides that internal law may not be invoked as a justification for its failure to perform a treaty. Let's take an example, Article 21. Article 21 of Chinese Coast Guard law provides the power to Chinese Coast Guard ships to take control measures over foreign warship or other government ships for non-commercial purposes that violate China's domestic law in waters under China's jurisdiction. According to Article 21, the Chinese Coast Guard is authorized to warn to leave the area and take measures to control foreign warships. If the warships refuses to leave and may pose serious harm to or threat, the Chinese Coast Guard is now empowered to take measures such as forcible towing of the offending warships. What if this provision is applied over US warships engaged in freedom of navigation operations in the South China Sea? Since Chinese law on territorial seas and contiguous zone prohibits foreign military vessels from passing through the territorial waters without obtaining prior permission from Chinese government, the US Navy warship sailing within 12 nautical miles from Chinese occupied maritime features in South China Sea would violate Chinese domestic law. Then this article would authorize Chinese Coast Guard ships to carry out activities to force US warships to expel from the waters, even by co-warship towing. However, under international law, warships and government vessels operating for non-commercial purposes enjoy immunity from exercise jurisdiction by foreign states, as I mentioned. The UNCLOS does not have a clear provision to allow forcible measures against immune ships. In addition, the Permanent Court of Arbitration rejected China's so-called 9-line claim in the South China Sea Award in 2016. Nevertheless, the China Coast Guard ships may invoke the Chinese Coast Guard law to justify China's measures taken against foreign warship, which would not escalate the situation, but also be a challenge to the rule of law and the existing legal order by UNCLOS. Now, what would be the implication of Chinese Coast Guard law for the security environment around the Eastern Sea, where Chinese Coast Guard fleets regularly show their presence in the contiguous zone and intrude into the Japanese territorial sea of Senkaku Islands? Since last year, the trend of situation has been worsening, with an escalation in tensions with the highest number of presence in contiguous zone and longest intrusion into the territorial sea of Senkaku Islands. Japanese and Chinese Coast Guard vessels sail side by side almost every day, and even today. And besides, the Chinese Communist Party marks its 100th anniversary this year. Thus, China may expand its presence in the Eastern Sea to enhance its national prestige. Considering such circumstances, it will become more necessary to ensure that activities and incidents in the area do not escalate into something more significant by strictly observing existing international law, particularly UNCLOS. A hypothetical example would be a Chinese Coast Guard ship approaches a Japanese fishing boat in Japanese territorial waters near Senkaku Islands for boarding inspection or carrying out similar law enforcement activities, for example. At the same time, the JCG Coast Guard ship will cut into between the Chinese Coast Guard ship and the Japanese fishery boat to protect the Japanese boat and stop such law enforcement activities by Chinese Coast Guard in the territorial waters. During this operation, there could be a collision between Chinese and Japanese Coast Guard ships. Now, Chinese Coast Guard ships could take forcible measures in accordance with Chinese Coast Guard law against the Japanese Coast Guard ships, and these measures would trigger the escalation at sea. Until now, such accidents or crashes or incidents have never occurred between Japanese and Chinese vessels in the area. One reason for this is that international law, including the rule of navigation and immunities, has been respected and well observed on a mutual basis. International law plays a substantial role in preventing conflicts by providing immunities to warships and government vessels that are carrying out their official duties. It urges diplomatic solutions instead of using forcible measures on the scene. Therefore, in Japan-China high-level consultation on maritime affairs on February 3rd this year, Tokyo urges Beijing to respect the provisions of UNCLOS and to ensure that Chinese legislation, that is, including the Chinese Coast Guard law, is applied within the limit of the international law. One of the measures against Chinese challenge is to strengthen ties among nations that share the values of rule of law and freedom of navigation. The Japanese government should enhance the capability for patrolling its territorial waters in the first place, and also the government needs to strengthen Japan's alliance with the United States. However, it would be more important to ensure such universal values are strongly shared among the international society to lean China's ambitions. We believe in the value of the rule of law and do not allow China's power-based approach, which undermines rule-based approach. We do not have to wait until Chinese Coast Guard ships to take measures that constitute a violation of international law in East and South China Sea. We should warn Chinese governments that it would be a violation of international law if such provisions are actually invoked. And I will stop here, and I'm very looking forward to have discussion on this matter. Thank you very much.
Thank you very much, Captain Furuya. Our next and final speaker is Professor Donald Rothwell from the College of Law at the Australian National University, ANU. And today, Don will wrap up this panel by talking about UNCLOS, state practice, and the evolution of the law of the sea in the 2020s. Welcome, Don.
Thanks very much for that introduction, and it's terrific to be speaking today at this event. And can I just echo the comments of my fellow speakers and congratulate the organisers for being able to put on this event under all of the circumstances that we've been dealing with. I basically want to deal with the question of state practice and the law of the sea. And I'm wanting to make a plea for us as scholars and researchers and practitioners to begin to give some more attention to this in terms of the way in which ultimately we think about the law of the sea, and of course the law of the sea convention. But I'm wanting to emphasize that we're looking globally here at law of the sea. For those of us who are familiar with the area, which I'm assuming is everyone involved in this group, we're very well versed in how significant state practice has been in the development of the law of the sea, how customary international law has been so significant in the development of the law of the sea prior to 1958 with the first Geneva Conference. But then since 1958, and certainly in the period up to the commencement of the negotiations for the current UN Convention on the Law of the Sea. There are multiple examples where we've seen rapid development of state practice having significant impacts on the way in which the law of the sea evolved during that time. So this notion of state practice and the law of the sea is a phenomena that we're very well familiar with. And of course, to top that all off, the law of the sea has the distinction of having the most significant case on customary international law, which refers to state practice, that being the North Sea Continental Shelf case, one which actually deals with a law of the sea issue. So if we move then to thinking about the impact then of the 1982 Convention on the Law of the Sea, which of course entered into force in 1984, we're dealing now with quite a different situation that predated it. We're dealing with a convention of 320 articles, 9 annexes. Tommy Coe refers to the convention, of course, as a constitution of the oceans. And we see ongoing references to the Law of the Sea Convention being a living instrument. And indeed, in the South China Sea arbitration, the Annex 7 Arbitral Tribunal made direct reference to the fact that the law of the sea and the convention is not static. So that in itself suggests that there's going to be processes of evolution, processes of development in the law of the sea. And we need to be mindful that, of course, much of the law of the sea, not all of it, but much of the law of the sea that we look at today was in fact negotiated during the 1970s. Of course, there's also been discussion amongst scholars as to whether or not, well, could we foresee amendment of the Law of the Sea Convention to resolve some gaps, some inconsistencies, to resolve issues that have arisen since the adoption of the convention. Technically, the answer to that question is no, but I think practically and politically, we would all concede that the possibility of any such amendment of the convention occurring is rather remote. So I think by and large, especially given the state of multilateralism today and the enthusiasm or lack thereof for any new multilateral agreements, we are going to be living and working with the 1982 Convention on the Law of the Sea for many years to come. But I guess an interesting question for us to think about is there the potential for parallel customary international law of the sea to also develop? So the challenge I'm wanting to put out to us is to give some consideration to how is the law of the sea capable of responding to these issues in the 2020s. Is the law of the sea capable of interpretation? Well, clearly it is. And indeed, some of the presentations that we've just heard give us examples of that. Some aspects of the convention, you might say, are terms of art or are technical terms. And inevitably, they've been interpreted by the parties to the convention quite appropriately. The way in which the right of hot pursuit, for example, has been operationalised in a more digital era, or at a time when states have a range of diverse assets to engage in hot pursuit or maritime law enforcement, could perhaps be a good example of that, as opposed to the capacities of states to engage in these types of activities during the 1970s. So certainly there's been evolutions in interpretation. Have there been evolutions in state practice? Well, I think the answer to that quite clearly has to be yes, and I'll give you some examples of that in a moment. And to that end, of course, we need to recall that there are 168 state parties to the Law of the Sea Convention, and there are some states that are not parties to the convention, and one state in particular is not a party to the convention, yet is a very significant maritime state and a very significant interpreter of the law of the sea, and indeed of the Law of the Sea Convention itself. So once again, state practice is going to evolve, it's going to develop, and some of the issues that Stuart has raised, but more generally, the way in which states have interpreted and applied the EEZ provisions of the convention might be a good example of that. In the 1960s and 1970s, we had fishery zones, but it was only until the EEZ provisions were endorsed under the convention and the convention provisions were implemented that we actually see state practice in states actually interpreting and applying those quite complex provisions dealing with the EEZ, which cut across multiple different dimensions of the law of the sea. So I think we would all concede that, yes, state practice is critical in this area. But the difficulty is, well, how do we identify that state practice, and perhaps how do we interpret it? So let's start with basics. And obviously, and there's been some good reference to this already, the Vienna Convention on the Law of the Sea, Vienna Convention on the Law of Treaties is obviously an important starting point in terms of interpreting any treaty. We have Article 31 with respect to the general rules of interpretation, Article 32 with respect to the supplementary rules of interpretation. And if you look at Article 31 in particular, there are a set of intersecting rules of treaty interpretation, which you could summarise as being relying upon principles of good faith, relying upon the context of the instrument, and then in addition, and where appropriate, looking at subsequent agreements, subsequent practice, and relevant rules of international law in the relations between states. Now, in particular, Article 31(3)(b) talks about any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. So there's clearly an entree into looking at subsequent practice, and that's accepted under the VCLT. However, the threshold for meeting that test, when it's being considered by international courts and tribunals such as the International Court of Justice in the Botswana and Namibia case in 1999, or in the jurisprudence of the WTO, suggests that the threshold for meeting that standard is particularly high. Ost, in his leading work on modern treaty law and practice, the 3rd edition, commented as follows in relation to this. He says, "It is not necessary to show that each party has engaged in practice, only that all have accepted it, albeit tacitly." And I think that's an important point to acknowledge and accept, especially when we reflect upon some aspects of the convention. And while I'm at it, I want to refer you to an excellent collection of essays edited by Georg Nolte in 2013, Treaties and Subsequent Practice, a great collection of essays looking at precisely this issue, of which Victoria University's Campbell McLaughlin made a contribution. So let's think about the law of the sea and customary international law in particular, as opposed to the law of the sea as a treaty. Is it possible to suggest that there may well be a capacity for a separate and distinctive customary international law of the sea. And here I'm posing the challenge. Well, clearly in the 1940s and the 1950s, there was customary international law of the sea. Since then, our thinking and the discourse tends to have been dominated by the provisions of the Geneva Conventions and by the law itself. But is it still possible to say that in the era of the Law of the Sea Convention, we may well be addressing that today? I think it is. I think it is possible to say that there may well be the potential for the development of a separate and distinctive customary international law of the sea. That's not to say that this would necessarily subsume the Law of the Sea Convention, but it's certainly possible that if we think about issues associated with sea level rise, issues associated with the potential for statehood of artificial islands, and questions arising with respect to new maritime technologies and uses of the oceans, issues that are not really comprehensively, if at all, properly addressed under the provisions of the Law of the Sea Convention, there may well be scope and potential for the separate development of a distinctive customary international law of the sea that would effectively sit alongside the provisions of the Convention. So that brings us to the challenges of assessing developments in state practice. What state practice is accessible? Many of us will immediately go to look at the United Nations Division of Ocean Affairs and Law of the Sea website, but those of us who look at it carefully will concede that it's quite incomplete, it's patchy, yes, in parts it's reflective of good aspects of state practice, but it's by no means comprehensive. So what state practice can we easily see and observe? What state practice is conducted in the shadows, which we can't easily see and observe? And what levels of caution do we need to exercise with respect to the state practice of dominant states, those states who are very much on the front foot, who are very transparent in terms of their positions on a range of critical issues? Should we allow that dominant state or dominant state practice to prevail over state practice more globally? And here I have some experience in terms of the work that I did with the International Law Association Committee on Baselines on the International Law of the Sea. And there we struggled at times to be able to rely upon publicly available sources in terms of looking at baselines. And as the rapporteur of that committee, I needed to be very cautious of the prevalence of excellent material provided by the United States State Department, the Limits in the Sea series that we're all very familiar with, which has now published 149 reports over 51 years. So a lot of state practice, a lot of analysis of state practice contained within that series, but of course it's US dominated state practice. The South China Sea Award, of course, many of us know it's been criticised because of its failure to not properly engage with aspects of state practice, especially in terms of the interpretation of Article 121 of the Convention on Islands. It does directly refer to some of the points that I've been making, and it refers to Article 31.3 of the Vienna Convention on the Law of Treaties, and it made the following interesting observation. It says, this means that the parties must have acquiesced in such practice so that one can speak of an agreement reached concerning the interpretation of the provision in question. And then they observed that scrutinising the jurisprudence of the ICJ on this issue establishes that for accepting an agreement on the interpretation by state practice is quite high. So in the time remaining, I'll just give you two quick examples of some of the points I'm trying to make here. The first goes to what I said before about baselines. The work of the ILA committee was able to show that 90 coastal states had drawn straight baselines consistent with, or at least in reliance upon Article 7 of the Convention. But within that example of state practice, we saw wide varieties of state practice. We were able to draw some conclusions as to the way in which states were interpreting the provisions of the Convention, but ultimately we were not able to reach conclusions on one of the critical issues, and that is what is the appropriate length of a straight baseline. So it is possible to identify state practice. Being able to draw conclusions on that state practice can sometimes be very challenging, but at least I'll acknowledge that there was, to a degree, a fairly high level of transparency and availability of data and material on the length of straight baselines, though as one member of the committee would often remind us, one needs to exercise caution because one could never be clear as to what levels of diplomatic practice, or diplomatic protest, I should say, was undertaken behind the scenes. And of course, that would be relevant in terms of understanding how states were accepting, tacitly accepting, to refer to that term I noted beforehand on that point. Archaeologic states is another interesting area of interest, perhaps an easier area to study because there are only 22 declared and recognised archaeologic states. And here we have, once again, a fairly high level of transparency in terms of the state practice, in terms of the declaration of archaeologic baselines, states declaring themselves as being archaeologic states, the regulation and management of a whole range of issues associated with that. And so here I think that that level of state practice is of great assistance to us in terms of understanding the way in which states have interpreted those critical provisions in the convention. So to come to my concluding remarks, I guess the point I want to make is that as Law of the Sea scholars, we have quite rightly, I think, focused in the 50 odd years or so since the convention was concluded, focused on interpreting the terms of the convention, the articles of the convention. We've written treaties looking at these questions, but not so often do we focus on questions of state practice. And I think we need to perhaps give more attention to thinking about treaty evolution, treaty interpretation, and to understand how state practice may well be importantly evolving in certain areas, which will see variations with the actual text of the treaty, with the intention of the framers of the treaty. And so that, I think, raises questions as to whether or not we really accept and recognise that the Law of the Sea, as the so-called Constitution of the Oceans, is a living instrument. So my conclusions is that I think we all need to give more attention and focus on state practice. We need to seek to engage in more exhaustive studies on analysis of state practice. We need to give some consideration as to whether there are examples of regional state practice. And to that end, I note with delight the fact that there's recently been a publication by Tamanda and Zhao on the implementation of the convention, focusing on the state practice of China and Japan, and that indeed yearbooks of international law can play an important role in terms of highlighting state practice, and will acknowledge the work of the New Zealand yearbook in, I believe, having an annual entry looking at New Zealand state practice on the Law of the Sea. Thank you, and I look forward to the discussion.